Pleased to see you again. I prepare to attend this class. So we are about to begin with a criminal procedure in England, and we have surveyed the reform suggestion filed by a Departmental Committee of Jury Service. Actually, the public policy is now considered the important, and as you see later, for example, the carnage against the accused was long been long practiced. For example, a placement of the accused in dock, placement of counsel next to each other, wigs and robes worn by counsel, and a lack of prosecution witness interviewing by the defense, for example. In some context, the doctrine of presumption of innocence may be questioned in some context. But the reform has achieved much success to restore the balance of justice between the defendants and a prosecution. Actually, the Edinburgh system was more preferred and practically considered to originate from the United States context. We have some comparative analysis by Graham comments on the English criminal jury trial from tightening the reins of justice in America. The article purported to put a mess about some anomaly and some point of irrational points need to be reformed, but the illustration was drawn heavily from the British context, actually. So the system or institution is actually malleable, but the public policy also need to have some insights about the wake of history and the genuine aspect of a historical evolution. So that is the point which would make me available to begin with our policy reform. For example, there are several theories usually available in the discourse of a workplace democracy, for example, which incorporates a economic argument and a ethical consideration about workplace democracy. And also there is another strong profile of a scholasticism about a citizenship argument in the workplace democracy. I'm not sure if the jury issue of a jury system involves the workplace democracy. Usually it is a separate issue that is not pertinent in interchange about the metaphor or a rhetoric, but we may not go that way entirely. For example, the judges may impose some context of a hierarchy in the criminal procedure between judges and jurors, a group of jurors. In some process, the jurors may be elevated into the kind of a high stand interchangeable with a judge calls. The words used in the courtroom different across the jurisdictions. In some cases, small separate space was assigned to a group of jurors, which is patently approaching as kind of a democratic way. In these days, we see some troubles about the court words practiced by judges, verbal abuse or other profane words were used, but they are not serious actually in comparison with other jurisdictions. Some jurisdiction may get it publicly exposed. The exposure is notable in the use of a different language. They are not downgraded, unlike Korea, but usually have some points of honor to boost the peer judges. The professional group in that way may separate from the operation of jurors. So what has that difference, connotation or implications in understanding the virtue of a jury system. It is a delicate point that we need to compare as a comparatist. So, before the criminal procedure, I'd like to provide some comment, which is productive to get the essence of this jury system. The changes prompted by Morris Committee enlarged the pool and the composition. No longer were juries, as Lord Devlin had commented, predominantly male, middle-aged, middle-minded, and middle class. The jury had been male because few women satisfied the property qualification. It had been middle-aged because the age limits were 21 to 60, now changed to 18 to 65. It had been middle-minded and middle class because exempted were principally peers, members of parliament, country and town councillors, lawyers, clergymen, a variety of medical persons, soldiers, sailors, policemen, and post office workers. Lord Devlin had noted the apparent inconsistency between the limited qualification and much earlier granted a universal suffrage. So we can see some context of a transformation in his words. Let's see. It may seem surprising that in a country which has had universal suffrage for longer than a generation, the jury should still rest upon a comparatively narrow base. Looked at from that angle, the argument for change seems very strong. But it might be dangerous so long as the unanimity rule is retained, to equate the jury franchise with the right to vote. No one expects the country to be unanimous in favor of the Conservative Party, but the jury must be unanimous for a plaintiff or a defendant. The approach to unanimity must be helped to some extent by the fact that the jury is drawn from the central block of the population, and it is difficult to estimate what the effect might be of the inclusion of more diversified elements. If unanimity is insisted upon and the narrow franchise preferred, It is no doubt right the juries should be taken out of middle of the community where the safe judgment is most likely to repose. The new exempt list was basically limited to judges, persons involved with the administration of justice, and the clergy, a decided decrease in the scope of those excused by law rather than by the court. It is the excuse by the court, which in English law is a considerable variance with the United States practice. Challenges to the entire panel are infrequent in both systems, but challenges for cause and preemptive challenges have little resemblance to one another. Turning again to Lord Devlin, he describes the situation in the mid-1950s. So we have some introduction, a point of a focus raised by Lord Devlin, but I like to forego that argument. Actually, we have one practical importance may be found in the use of juror. We have a jurors galore in the list, but how do we properly select to yield the most justice in the case? If that is not the matter of public policy, and there are many points to be considered in reform and administering a juror system. So effective or efficient should be one factor. In terms of a public administration also. Actually, the institutional reform, the ideas may be emulating each other in points of a various aspect, the historical element or traditions and the resources of nation. As I have said, the citizenship argument can come in right way to address a proper arrangement of a public institution, for example. This thing, if the workplace is the very space where the citizenship may be fostered, so, for example, we may have some modest democratic citizen in the factory, which is the outcome of the effective administration by ensuring a democratic form of management. There are a difficult points of argument about the extent of a workplace democracy, but why do we see it relevant and kind of a desideratum, or where the court is the place of a democratic experiment between the jurors and the judges. So, how about a criminal procedure in England? See, I'd like to make a general introduction. The London criminal courts are filled with tourists during the summer months. These often are a premium at the Central Criminal Court and the Bow Street Magistrate Court. Even a lay observer could know contrast from the American system. Have you ever traveled England or London? The most obvious seem superficial and traditional, the wearing of wigs and robes. The accused alone in dock, police officers testifying by reading from their notes. But these simple and more obvious observations are part of a large aggregate of variations from the American system of criminal procedure. And they are more than a form. They have evolved over centuries. They improved and become more civilized. Until the late 16th century, an accused was detained until trial with no opportunity to prepare a defense. He was not informed of the evidence to be used against him or of those who would testify for the prosecution. So, as I mentioned, the adversary system was seriously not ensured. Nor could he call any witnesses on his own behalf. He could not even have counsel were accused of treason or felony. He stood isolated against the state. The changes in criminal procedure in the past few centuries, and most importantly since the mid to late 19th century, are almost without exception changes that benefit the accused. So we have much improvement, which is now enabling a proper comparison with modernized criminal jurisdiction. But there is less public criticism in England than in the United States that the balance has swung too far in favor of protecting the interests of the accused, to the detriment of society. The process, nevertheless, retains elements of the early trial, the notion that it is a form of combat. So we have some paradoxes about the highest power of Great Britain and the latest reform about many civilizations. So it is delicate point about history and reform, with conservative ethos kind of may well be preserved if the country may pump through the series of political success. But what if it undertake the Japanese example in recent progress? Do you see it is art to pump through a strong statism, is a kind of fascism, do you have critical perception against them, or do you enchant some fantasy on that mainstream in Japan? They still manage the system of empire, which is symbolic, of course. They are actually a parliamentary government practiced in the democratic terms, but their spirit and historical attitudes have not been corrected. Do they see they were not defeated in Second World War, or what? It's interesting. But some points of a strategy in this area of East Asia and new international politics may find a proper soil for revision of a power balance. So there may not be antagonism in pure sense or logic, but kind of a realistic confrontation among what? As kind of economic reason or any? Do we see some dynamism involving a political hegemony What are they for? What does it mean by the apology of a sovereign person in Japan past years? Then, I'd like to show you some points based on the article titled Law Machine, authored by Burns Dyer in 1982. But while over the centuries, the criminal trial has become more sophisticated and its procedure more balanced to achieve justice, the inherent concept of combat contest has remained a feature throughout. There is challenger, the accuser, and a defender. Instead of swords and lances, the weapons are facts and legal arguments. Each side has a champion, the lawyer. There is an arbiter to make sure that the contest is fought fairly according to the law. To the casual observer, the trial still appears like a strange ritual in which the judge, the lawyers, and to some extent the court officials are participants, but the rest, including the accused and the jury, are excluded. There are remnants of medieval language used. Judges and barristers continue to wear costumes appropriate to different countries. Above all, it becomes clear that there are two languages being spoken. The judges and barristers use one, and everyone else another. The language of the law is ultra-polite. It is not as same as some judges of misconduct accused this time. A reprimand or criticism is delivered in such superficially amiable terms that only those who speak the language realize the sting. Senior judges are addressed as my lord, as it sounds, my lord, even though they are not peers. Junior judges are your honor. Barristers refer to each other as my learned friend, even in the heat of dispute. The judge's opinion or remark, however ludicrous or outrageous, is always treated with respect or even with grace or respect. However far that may from the truth, lawyers speak even when they are addressing witnesses in an old-fashioned, convoluted way, seldom used in real life. The fact is that the barristers and the judges belong to the same club. They follow its rules and keep its traditions, and non-members cannot be part of the ritual. Defendants in criminal trials, litigants in civil cases, are often disconcerted and upset by the apparent chumminess between lawyers who they think ought to be passionately antagonistic. So, the English and American systems have been subjected to their own separate stresses and reform movements. Significant differences have evolved. The primary focus raised by Professor Graham is a reform of the American system, not present objective analysis of the English system. But it makes useful observations on some differences in the two systems. So, what is his argument? For example, the legal machinery trial, from initial appearance to arraignment, is simple, quick, and cost-efficient. The police prepare statements of witnesses and provide them to the defense prior to the uncontested Section 1 committal. The police also freely disclose exhibits to the accused. In turn, the accused provides a notice of a elevated defense. Only the police see witnesses for the prosecution prior to trial. Legal executives employed by defense solicitors interview the accused and take statements from defense witnesses. Rarely does anyone on the defense side attempt to interview a prosecution witness. Neither the prosecution solicitor's office nor the defense solicitor employs private investigators. So, as you note, we once get basic idea about the criminal jurisdiction in Great Britain, and in the context, majestic courts often deal with a majority of criminal cases, but some major criminal accusation may be relegated up to the higher court, what I call a crown court, and the criminal procedure are simple, quick, and cost efficient in England, but there are some difficulties which I would rather be ungrounded and in the context of a modern standard. For example, placement of the accused in dock, a placement of counsel next to each other, lack of a body. So the body, as I've said, is a unique point the American jury system have employed to their business. Lack of prosecution witness interviewing by the defense. Permitting police officers to read from their notes in open court. Lack of cross-examination. Placement of defendants opening speech following the close of the prosecution case in chief. So, the aspect of a history determines some delicacies in variance with the respective jurisdictions, although we call it collectively as a common law system or socialist. In some sense, it is democratic in the kind of a element also supported by a socialist states pertaining to a jury system, which is however, our usual but also a convincing understanding about the democratic nature. Then, how come the jury trial in the context of a criminal trials? The near absence of juries in civil trials has been discussed in the previous section. We noted the contrast in jury use in general regarding the selection process and the lack of body in England, as we know it in the United States. But the jury vetting process does function as a means of eliminating a prospective jurors, however different it may be from the American body. The English process has elements of secrecy and obviously is not viewed as an effective means for defense counsel to challenge a prospective jurors. It is a process tilted sharply to the interests of a prosecution. If those interests are to achieve a just result rather than to win, then perhaps it is not in fact tilted against the defendant, but in favor of a fairness. The use of jury in England in criminal trials remains important, but not in terms of numbers. Most crimes are disposed of in the majestic courts, but the most serious crimes continue to be tried before jury in a crown court. That is right. This is right, which exists in most common law nations. The procedural elements in selecting the jury and in the nature of its verdict, however, vary markedly among the systems. In some systems, the alterations to the judge and jury have been so extensive that the result appears close to a civil or mixed form of decision making. Within each system and across the boundaries of legal traditions, the goal appears to be how best may a mix of lay and professional persons be used to seek a fair and just result. The United States clings to the use of jury more tenaciously than does England. The English jury is one of the institutions of trial procedure which was implanted in the extensive and culturally diverse empire. The development of the jury in several common law nations assumed attributes not dissimilar to the collegiate courts of first instance in some civil law nations. The professional judges were joined by lay assessors. A few members of jury moved from the jury box to the bench. The remainder went home. But in some nations, there was a reluctance to move the lay assessor to the bench. They sat instead apart from him, appearing more like a small jury than a collegiate bench. Moore outlines some of this commonest development. Is it at all significant how the system places professional and lay participants in the courtroom? Should not be more concerned with what role they each serve, who decides issues of law. Do lay members have the power to overrule the professional judge, where the former participate in legal issue decisions? What might be the best separation of responsibilities from the perspective of just legal machinery? And what might be the most appropriate courtroom layout to fulfill that goal? And second, considering cultural and social elements such as the impact on the litigants or accused of separation of judge and jury assessors, or should we use a single bench where all sit in a uniform level of apparent importance? Those are the points for your further inquiry. So, the last context arises from the verdict involving the jury trial. So, what is the unanimity? A striking difference in jury procedure involves the verdict. The majority verdict in criminal case appears to be a practice whose time has come. It is being adopted in various states in the United States, and the pattern has been to allow a smaller majority than the English view. The accused is believed to have enough in his favor in the modern procedural rules, and the impact of a single obstinate juror is sought to justify this important change from the early common law adherence to the unanimous verdict. Thus, the difference is not between or among common law national systems, but within contemporary practice and the historical mandate of a unanimous verdict. The difference, which does exist, is diminishing. The verdict in English criminal law long mandated unanimity. The Criminal Justice Act 1967 introduced a major change, the majority verdict. Then, let me read the Criminal Justice Act 1967. the article ascertains, first, subject to following provisions of this action, the verdict of jury in criminal proceedings did not be unanimous. If, in a case where there are not less than 11 jurors, 10 of them agree on the verdict, and B, in a case where there are 10 jurors, 9 of them agree on the verdict. And a verdict authorized by this section is hereafter in this section referred to as a majority verdict. So, what do you prefer between majority verdict and unanimity? Is it just a historical remnant? And second, a court shall not accept the majority verdict of guilty unless the foreman of jury has stated in open court the number of jurors who respectively agreed to and dissented from the verdict. The court shall not accept the majority verdict unless it appears to the court that the jury have allowed less than 2 hours for deliberation or such longer period as the court thinks reasonable, having regard to the nature and complexity of the case. The criminal procedure systems of different common law nations may reflect the very contrasting treatment, but there is a more common element to the sentencing process, namely judicial discretion. Although there is some limited movement toward mandatory fixed sentences and general-wide judicial discretion contrasts with the more strict trial procedures. There is one feature in English sentencing which is unknown in the United States, where a defendant, having been found guilty by a majestic court, is believed by the majesties to have committed a crime for which the majesty lacked authority to grant sufficient sentencing. The majesty may refer the matter to the Crown Court for the imposition of sentence. A defendant appearing before a majestic court thus must be aware that the sentencing limitations of the majestic court are supplemented by those of the Crown Court. If a defendant before a majestic court believes there is likelihood of a reference to Crown Court for sentencing, he may well prefer to have the entire matter referred to the Crown Court for trial. The reason accused persons tend to avoid requesting a trial in the Crown Court, however, is an expectation of a modest sentence by majesties in return for an almost certain conviction. Then you see more desirable in criminal proceeding, the jury system, and the jury trial in England are exclusively ensured in a Crown Court other than a majestic court, and the sentencing level also a factor to distinguish both jurisdictions. So we hasten to the next topic, which concerns the appellate procedure. Let's give some outline in purview of a general introduction about a appellate procedure in England. In the early development of common law, an appeal lay only to challenge an error on the record. One saw the writ of error and then pursue the process which to us seems unwieldy. A review of judgment alleging that the court reached the wrong conclusion later was recognized in the Chancery Court. Thus appeals developed as part of common law, recognized not by statute, but in the same manner as otherwise, as the way things ought to be by the judiciary. When the lower courts were abolished, the right of appeal was incorporated into the statutory framework, the primary source being the Judicature Acts. An appellant now seeks to reverse judgment as incorrect in law, which in a narrow sense constitutes a rehearsing, since judgment may be reversed or some other judgment substituted. But it is not a rehearing in the manner of the rehearing of civil law appellate court, where new evidence will be heard and there is a de novo proceeding. Now, evidence may be presented in English appeal, but it very rarely is, and is accepted only where it could not have been obtained for use at trial, suggests an important influence on the result, and seems reasonably creditable. The most frequent acceptance of new evidence is in an interlocutory appeal, not an appeal from the trial judgment. Although the appellate court does rehear the case, English judges are far more hesitant to interfere with the discretionary power of trial judges than in the United States. But they do often overrule procedural determinations. The statutory scheme designates the Court of Appeal as the appellate body of the Supreme Court, to which appeals are directed from divisions of the High Court, from the county courts, or from interlocutory orders of judges in chambers or masters on pretrial issues. The Court of Appeal uniquely is an appellate court, a characteristic also of judicial law of the House of Lords. Both are very limited, a special original jurisdiction. The trial courts, contrastingly, possess an extremely qualified law in the appellate process. The Court of Appeal has become the appellate court into which are channeled appeals from both royal civil and criminal courts. Prior to the Criminal Appeal Act 1966, there was a special court of criminal appeal, but the appeal of criminal cases has a brief history. Before 1848, there was no appeal in criminal matters for indictable offenses. The only recourse was to seek a pardon where there was an appearance mistake. Appeals on issues of law were established first in the court for Crown Cases Act 1848, but restricted to technical errors. The centralized role of the Court of Appeal as the exclusive civil and criminal appellate court is further supported by its jurisdiction of appeals from courts of special jurisdiction and tribunals. The special courts do not have a full procedural hierarchy, including a special appellate court, such as exists in many civil systems. A new appellate level was added to English law by entrance into European Economic Community. The European Court of Justice in Luxembourg interprets the Treaty of Rome, and English courts confronted with such an issue may refer the matter to this European Court, and must do so if there is no judicial remedy from the English court before which the case is pending. The treaty is unlike English legislation. The latter is more exact, and judges tend to limit its application only to those circumstances which precisely fit the wording of the statute. So the tradition shares a common attributes between England and United States, as I've said. The perspective about international law and the relationship with domestic laws are a little distinguishable, and it is usual to practice a presumption of a presumption of treaty, which has limited a scope of a incorporation. So, for example, the code usually apply in a restrict sense by finding the express language that the treaty is the law, and which is includes a more definite terms compatible with the extent of a domestic provisions. So same goes in practice in both treaties usually. So some kind of a delicacies and differences in the perspective of a nature of various norms. But the treaty often states general principles, and where the English court interprets provisions, the judge must consider the intent and spirit of the treaty. They must not act as traditional English judges. As in the United States, some appeals are matter of right, others require judicial permission. In England, immediately after the decision is rendered by the Court of Appeal, a party may ask the court for leave to appeal. The judges usually respond immediately rather than reserving judgment. If the request is denied, then the party may ask the House of Lords to permit the appeal, thus giving two chances for the review. The appeal committee of the House of Lords hears oral arguments on the petition, and much like the judges of Court of Appeal, responds immediately without reserving a judgment. An appeal may require an accurate transcript of trial process. Modern machines are beginning to encroach upon the fountain pen. Will better transcripts increase the rate of appeal, or simply make those brought more effectively heard? The dialogue is useful to practically unravel the tedious process of trying to keep up with the witness. It was given by Silverbill Baffle, the faces of justice. So the witness reads the oath, gives and spells her name, her address and occupation. She runs a sweet shop in Belgravia. He came into the shop. I thought he was a child. I thought he was going to buy a bar of chocolate or something. Suddenly he puts up a revolver. The clerk said, just a moment, madam. Not quite so fast, if you please. The witness stops in her tracks. The magistrate leans over and explains to her that she has to be followed by pen. Oh, I see. Yes, madam, says the clerk. A bit of a stride. Well, then he said to me, the clerk formed. He came into the shop. Do you see him here? Yes, she says without looking. Where? There. In due course, the evidence is read back. Human speech is not easy caught up with, even with the fast fountain pen. It comes out something like this. He come into shop. I thought he was going to purchase something. He suddenly put a revolver on the counter. A handkerchief was pressed away. He said, "Give me your money." The witness signed this record, left the box, and was asked to sit down in the back of the court. A major contrast in allowing appeals with the United States system is the limitation in England of criminal appeals to the Court of Appeal from the Crown Court. The Criminal Division of the Court of Appeal is permitted to allow an appeal and quash the decision, or it may order retrial, but only if there is a fresh evidence. Finally, it may apply the provision that permits the court to agree that there is reason for the appeal, but to hold further proceedings because no substantial miscarriage of justice occurred. Studies have suggested in many of these cases serious error had occurred. So errors are often found, and nature of things and business how to correct the errors, or perhaps a erroneous ruling of trial court in the face of justice. So there must be some limitations in human dealings and ways of a reaction. Most civilized form of response can be found in appellate review. But there is also questions if how the Supreme Court has utility as a final authority of justice. Then we're going to close the review of a procedural aspect in England. And now we begin with our exploration about legal rules in England. How are sources of law in England? I remind of the past lecture concerning the civil law system. So you may have a comparative tools to see the differences. For example, the major source of law may be found in precedent, and reporting of cases are important. And of course, the common law system dictates judges to be bound by a precedent. So we have to draw upon the binding nature of cases as a source of law. And we also have some points of review about case law developed by the European Court of Justice in the context of a judicial tradition. And also, it is useful to have some purview about judicial style. It needs to be comparative in understanding the common law system. So, Professor Goto provided a point of comparative essence among France, England, and United States. Then, what are sources of law? Sources of law pertain not to how an ordinary citizen believes his conduct is governed, but to where courts look in determining what legal rules are applicable to resolve a specific dispute. Tradition often separates sources into written and unwritten. It is a confusing distinction intended to contrast laws which have been formally enacted from those which have not been enacted, the latter including judicial decisions and customs, and important in English law, conventions and the royal prerogative. The variety of sources of English law attest to its nature as a method of administering justice. Classification of sources is less important than the assigned values, particularly when the sources represent conflicting rules. How judges perceive the value of different sources additionally affects the manner in which they will apply a governing source of law. Value allocation to sources within the system is a slow evolutionary process. English judges traditionally have been less inclined to defer unquestioningly to legislation, particularly social reform legislation, than United States judges. So it is also a point of delicacy, although they are generally required to respect the statute. Disdain for social legislation has diminished slowly. The legal profession in England has bred an independent and pervasive sense of what is right. Paramount is a sensitivity for preserving an individual right to contract freely and to alienate a property. Social change is sought to be introduced appropriately through the adaptation of a precedent to new circumstances, not by means of legislation. The judiciary believes the dual code to social changes is illustrated by the development of common law decisions. Although there is no dispute, the legislation is source of law, which has authority over all other sources, and the legislation increasingly is assuming the major role as source of law. The fabric of the common law is its precedent, and the vast number of volumes of unwritten law is the foremost distinguishing feature of the common law tradition. Then we intend to see a precedent. How do we produce a precedent? The first context should come in reporting of cases. So annual, we trace back even to the years of 13th century. For example, most primitive report may be called yearbook. In any legal system, what judges have said in addressing issues in earlier disputes is likely to be of interest in subsequent cases with similar facts. If a judge assumes the earlier decisions in his court and in high courts were dealt with competently, there is no reason to suppose, in the absence of changed circumstances, that a similar result would be inappropriate. Continuity and predictability of the law are positive attributes. The theoretical usefulness of prior case law should not be any less in the legal system. Judges do not have to follow earlier decisions than where they are compelled to follow them, presupposing access to the substantive law in the other cases through an effective reporting system. So, we usually experience two forms of authority between a statute and a case report. So a physical way of approach may be simplistic, but allow you have some bright ideas about the separation purpose, a distinguishment purpose. You firstly go to a case report to find what the law should be, or what do you have about law. But in contrast, you may have a first-hand priority about the statute. What's that? Precedents are only as functional as their reporting. If reports were not available, precedent would have little value. Courts might refer to previous decisions, judges recall, but there would be little value in the system to decisions which could not be used by advocates as well as judges. Who report cases and what they contain, those are questions which to be considered before discussing the binding nature of case law and judicial interpretation of prior decisions. English law reports develop very slowly without a government participation. They continue to be the product of a private enterprise system which chooses which cases shall be reported, often on the basis of the economies of including a particular judgment. Yearbooks developed in the late 13th century, consisting essentially of notes compiled by advocates, but under no pretext that they were to be used by judges as precedent. Still, they were used for their purpose occasionally, increasingly so by the 15th century, when publication of the yearbooks ceased. Private reports were produced, initially in the name of particular law reporter. They proliferated for 3 centuries until in the mid-19th century, a semi-official council was formed for the purpose of reporting cases in England and Wales. The law reports, which have now replaced most of private series, are not the exclusive location for the publication of cases, but convention suggests they are the reports which to be referred to when citing decisions. The system of reporting is less formal than in the United States, as you have been introduced. It is a different practices in reporting of court case. In the United States usually managed a public system where the government, specifically each court of jurisdiction, is responsible to publish their cases. That is not the case in English throughout the history, but recently that converges since some evolution noted about a semi-official institution responsible to publish the case law. In both nations, the publishing of decisions left to private enterprises, but there is considerable difference in the official status of reports, in how decisions are selected for reporting, in the form of decision rendered by judges, in the volume of cases reporting. Those outline some of the unique attributes of the English system and how it differs from the United States method. And the product of most research of practicing lawyers is only as effective as the preparation of digests. How much valuable precedent is overlooked in the bloated reporter system remains unknown. That a system has reported decisions, which is increasing an attribute of civil law as well as common law systems, does not therefore mean they are valued by the system pari passu with another legal system. They may not have value within the system in deciding future cases, or they may have some value but not as we perceive the value in the United States. Decisions in civil law nations often refer to early cases as teaching something. But this does not mean the judge is compelled to learn the principle, or if does learn it, to apply it in his own case. Even within one system, precedential value may vary depending on the court which has rendered the decision, and the relationship of the court which rendered the decision of the court which it has considered. Where precedent has value assigned by the system, a characteristic most associated with common law tradition, some general rules tend to exist. The decisions of lower courts are not binding on higher court. The decisions of higher courts are binding on lower court, unless the decisions of highest binding on lower court. The more difficult question is whether the decisions of one court are binding on the same court in the future, and if there is divisional court at a particular level, where the decisions, if binding on the same division, are also binding on other divisions. The rules in the English system will illustrate both. They differ from those in the United States, and expected from civil law systems, and that there are rules in motion, changing to meet the demands of time. So the principle of stare decisis also possesses some delicacies in difference among the communal nations themselves, and also they share the attribute which they employ some private enterprises to publish the court reports, but the issue is which authority actually determines the scope of case reportable. It is serious. And as I've said, in several countries, including Korea, the Supreme Court and some the administrative a unit of highest nature is responsible to collect cases and analyze the merits to be publishable or others. And as you see, the Professor Yonglong Lee once engaged in the kind of job in his youth of years as a graduate student in SNU. So in the next class, we are available of a further points in the context of a binding nature of cases. So what are the genuine intrinsics ascribed to the case laws in England also. And for the purpose, we expect to review the article titled Discipline of Law, which was presented by Lord Denning. So I like to have have you on this class in the internet space. So I expect you regularly attend the two classes, which would be uploaded later in next day, usually a Thursday. So I expect to meet you on Friday in morning class. Thank you for your attendance.